I want to retain all rights. I don't want to waive any rights.
And that's not really how it works.
Welcome back to part 11 of our multi-part series featuring Rockingham County, NC. The corruption is thick in this county, and we've covered a lot so far, so if you missed any of our previous videos, please feel free to head over the playlist and check out the others. In the previous video, we covered the first two WebEx hearings that were granted in Rockingham County Superior Court. Mike fired his attorney back in December of 2021 and was going to defend himself. The judges in both WebEx proceedings, Judges Allen and Wilson, ignored Mike's motions, even though Judge Wilson acknowledged they were filed and before the court. Judge Wilson, on January 11th, would not even tell Mike what accommodations would be made for the January 24th hearing. He did agree to send a message via the clerk to the next judge about the issue. Check out part 9 of this series for both hearings. Almost immediately after that WebEx hearing with Judge Wilson on January 11th, 2022, Mike received an email from Barbara Reb telling Mike that all his ADA accommodations for the pretrial hearing to be held on January 24th, 2022 were denied by the trial judge, Judge Albright. Both Rockingham and Guilford County Superior Courts had granted the following for the previous 4 pretrial hearings: WebEx remote hearing, use of audio recording devices for audio notes, use of video recording devices for visual notes, only one person speaks at a time, no threats, intimidation, and coercion, use of personal assistant as auxiliary aid in the hearing, documents sent via email in OCR compatible format, all parties will identify prior to speaking, use of iPhone for access to court preparation materials and notes. Mike replied with his ADA request. He renewed the standing accommodations that were previously granted in Superior Court. And, should the WebEx request be denied, he made additional requests to facilitate equal access to be physically present in the courtroom. Mike didn't hear a response on what accommodations would be made until Friday afternoon, one business day before Mike's court date of Monday, January 24th. The email correspondence through Barbara Reb was coming from Judge Albright. He denied Mike's request for WebEx hearing, his request for the court to provide a visual interpreter, his request for his use of an audio recording device, a video recording device, his ball cap, and his dark sunglasses. Although the email communication was still meeting the requirements of handling the accommodations request administratively, this communication didn't occur until late Friday afternoon. Mike responded and informed Judge Albright of some of the reasons why he needed these accommodations, even though Judge Albright failed to inquire as to how granting the accommodations would assist Mike with performing activities he can't otherwise perform due to disabilities. The ADA, pursuant to 28 CFR 35.1307I, states, "A public entity shall make reasonable modifications in policies, practices, or procedures when the modifications are necessary to avoid discrimination on the basis of disability, unless the public entity can demonstrate that making the modifications would fundamentally alter the nature of the service, program, or activity." Judge Albright made no such demonstration. Remember, most of the requests had already been previously granted 4 times by the Rockingham and Guilford County Superior Courts, demonstrating they were not an undue burden, nor did they fundamentally alter the nature of proceedings of the court. It was looking like things had taken yet another very dangerous turn and had reverted back to their previous level of discrimination and abuse. Back at the end of 2020, District Court Judge Chris Freeman illegally and improperly denied Mike's ADA requests, like Superior Court Judge Stuart Albright is doing here. Freeman further violated Mike's rights by issuing an order threatening to hold Mike in contempt should he dare to attend court with his assistive devices. Mike responded in attempts to help Freeman understand the importance of equal access in due process, like Mike is doing here, and how important his assistive devices are to his everyday life. Check out video 3 for that part of the story. Now Mike is faced with communication from Judge Albright threatening that Mike must show up in person without his prosthetics or a visual interpreter, or be thrown in another cage to be abused and tortured again and have the $50,000 revoked. To complicate matters further, Prosecutor Cockman sent an email to Mike in the court on January 19th with a motion to continue on the grounds that Mr. Cockman tested positive for COVID and still needed to quarantine according to the county health guidelines. Judge Albright ordered all parties be physically present in court for Monday, January 24th of 2022, despite Mike's previous messages and accessibility requests, informing the judge that he cannot tolerate a mask for medical reasons. Keep this in mind, as this will be very important on the following day. It would seem as if this judge had a complete disregard for the ADA, Mike's health, well-being, equal access, and due process. Judge Albright could have continued the case until they administratively handled all the ADA accommodations to a level that granted Mike equal access and due process. But he chose not to do so. Instead, he forced Mike into the courtroom under threat of arrest via his judicial powers to issue a failure to appear warrant. This directly violates 42 U.S.C. 12203. The lower court in Rockingham County already made good on that threat on October 6, 2020, regarding this very case. So Mike had good reason to take the judge's threat as a credible one. Mike was therefore forced to accept the level of accommodations established late Friday afternoon, January 21, 2022, of direct violation of 42 U.S.C. 12201 and 28 CFR 35.160b2. Monday morning of January 24, 2022. Mike entered the courtroom before 10 a.m. with his auxiliary aide, Mr. Simmons. He immediately noticed the level of overhead lights was too bright for him. So as soon as they found their seats, Mike wrapped a scarf around his eyes and sunglasses to try to protect himself from the lights and prevent a migraine that could render him incapacitated and unable to function. When Judge Albright called the case, he showed clear prejudice towards Mike in open court. He ordered Mike to remove his scarf and accused him of theatrics. This was a very dangerous situation for Mike. Mike knew that taking the scarf off could leave him unable to function, let alone render a defense or present an argument in open court. Mike also knew that if he didn't do as a judge ordered in the courtroom, the judge could hold him in contempt and throw him in jail. Mike indicated to Simmons that he was being threatened, coerced, and intimidated, and his aide informed the judge. See 42 U.S.C. 12203. Judge Albright, perhaps realizing his error, changed the order to a request to remove the scarf. Mike was then able to reply with a verbal ADA request for reasonable modification for effective communication, to be able to use the scarf, or that they lower the lights for the same stated reasons he needs his glasses and hat. The judge didn't confirm or deny the request, but moved on. This was just the beginning of a long, demeaning, two-day ordeal. Up next is a brief summary of what transpired during that first day, followed by the audio recording of January 24, 2022, so you can listen to the unedited proceedings for yourself. Be sure to stick around because Mike was forced to return on the 25th without his auxiliary aide, Mr. Simmons, and was again blocked from entering the courthouse on the courthouse steps. Will this be a repeat of October 6, 2020? Back to the courtroom. Once the judge dropped the scarf issue, he tried to have someone hand Mike a piece of paper with a waiver of rights. Mike reminded the judge that he can't read the paper and asked for it to be given to him in OCR compatible format so he could read it, an accommodation that the judge had already agreed to. But instead of sending Mike the document in a way that he could read, the judge ordered Simmons to read it to him. Mike objected to this as it violates 28 CFR 35.160 and 42 U.S.C. 12203. Mike and his aide knew that if Simmons refused the order of the judge, he could be held in contempt and thrown in jail. Simmons was coerced into acting as an interpreter. The ADA clearly says what functions the auxiliary aide performs is up to what the person with disabilities and the auxiliary aide agree upon. It also says that the public entity can't force an individual accompanying the person with disability to act as an interpreter. 28 CFR 35.160C. Things didn't get any better from here. The judge asked the prosecutor if he would be presenting any videos, and then ordered that Mike and Simmons go with the COVID symptomatic prosecutor into a room to review 3 hours of video without a visual interpreter present. The judge instructed Mike's auxiliary aide to again act as his visual interpreter and recess the case until 3 p.m. I have a question for you. Does being able to hear qualify you to be a deaf interpreter? Does being able to speak qualify you to be a language interpreter? Possessing the ability to see does not qualify you to be a visual interpreter. To get a very rudimentary idea of what a visual interpreter can do, turn on a major streaming platform, select a recent movie or show, and in the language accessibility options, select English AD, audio descriptions. Play the show as you normally would, and you will hear a voice giving audio descriptions of some of the visuals on the screen. Keep in mind that this version of visual interpretation is for entertainment purposes and was written, recorded, and edited in for precise timing. A live interpretation would be very different based on the situation and the specific instructions of the blind individual utilizing the service. On his way out of the courtroom, Mike heard the judge addressing an observer in the audience. This individual turned out to be a person who had previously served as Mike's auxiliary aide in this case and had come to observe. The judge addressed him after the bailiff told the judge the man was shaking his head in disapproval of the discrimination the judge was showing Mike. Judge Albright ordered the man to stand and identify himself. The man stood and calmly asked the judge why the judge wanted him to identify. The judge kept demanding the man's identity without justification. When the man would not relinquish his rights, Judge Albright ordered the man be removed from the courtroom. C-42 U.S.C. 12203. Meanwhile, once in the room with the prosecutor, Mike made an ADA request for reasonable modification for effective communication directly to Mr. Cockman to provide him with a visual interpreter to allow Mike to have access to the visual information in the videos. Cockman scoffed and did not accept or process Mike's ADA request, but instead denied it without cause, therefore denying Mike equal access to the visual information in the videos. Mike's auxiliary aide gave some visual information because the judge coerced him to do so, but this was not at Mike's request. Visual interpretation is not one of the functions that Mike's auxiliary aide had agreed to perform. Though he did his best, he only attempted to give visual interpretation because of the coercion of the judge. As of the date of this recording, Mike has yet to be given equal access to the visual information in those videos. Mike and Simmons returned for the afternoon session to find that the lights were dimmed enough for Mike to not need the scarf around his eyes, so he didn't wear it. Once court began, Judge Albright called his own witnesses to testify on his own behalf. In a very strange turn of focus, he prejudicially went through theatrics for the record in attempts to show on the record that Mike was given opportunity to review the videos. This is simply false. Mike objected and explained as he was never given a visual interpreter and was denied the ability to take notes when videos were played. This is not access. Somehow the judge had even arranged for a surprise witness, Captain Jason White, from the Madison Police Department, to be in the courtroom so the judge could use White's testimony in his theatrics for the record. The judge went on and on, making a huge spectacle of how he believed he was making accommodations for the blind man and how gracious and benevolent he was being. The whole ordeal was nothing more than spotlighting Mike, the person with disabilities, which is prejudicial and discriminatory. Judge Albright put on this show in an attempt to wrap himself in his protective cloak of judicial immunity instead of handling the accommodations administratively. He abused his position by attempting to handle the ADA accommodations in the judicial setting, and Mike was powerless to stop him. Judge Albright proceeded to read through Mike's administrative ADA request line by line in open court. The judge had Mike's motion to dismiss based on lack of due process, which names him as one of the chief violators of Mike's rights. But instead of recusing himself, he made a mockery of the court, the U.S. Constitution, the ADA, and persons with disabilities everywhere as he tried to cover his tracks. Before Mike was allowed to argue his motion to dismiss, he informed Judge Albright how his bone-conducting headset works with his phone. Mike uses his hand gestures on the phone, and the phone reads to him through the headset. The headset does not obstruct his ears, so he explained to the judge that he can't understand what his phone is reading to him at the same time others are speaking. Mike asked that if the judge sees him trying to refer to his notes on his phone, or if Mike mentions needing a minute to refer to his notes, to please refrain from speaking as he won't be able to hear either communication. Instead of honoring that request, Judge Albright mockingly spoke simultaneously when Mike was referencing his notes multiple times, saying things like, "Let the record reflect that the defendant is reviewing his notes now on his phone, and let the record reflect he's reviewing his notes again on his phone." This is clear discrimination, as he didn't do that when the prosecutor reviewed his notes, and he didn't do it in the case before Mike's was called in the afternoon. Again, he spotlighted the disabled man for all in attendance and for the record. I think that's enough summary for now. Please listen to the complete audio of the proceedings of January 24th, 2022 for yourself, and let me know what you think in the comments. Court didn't adjourn for the day until after 5 p.m. and was scheduled to reconvene the following morning, January 25th, 2022. But remember the COVID-positive prosecutor that Mike and Mr. Simmons had been in close proximity to for hours? I'll leave that bit for the next video as this one is already going to be lengthy, but I will say this. When Mike returned the next day, the deputies blocked him from attending court again. The following recording is of the AM session on January 24th, 2022 in the Rockingham County Superior Court.
Okay, y'all go ahead and have a seat. I don't know who's here for who, so we're on the record. For the state your name for the record, please.
Matt Cochran.
All right, Mr. Cochran, hold on a second. All right, for the defendant, Mr. Nelson, I assume that is you with the baseball hat on.
Yes, sir.
All right, I made a ruling based on your request. We'll go over that in more detail at a later time. I want to be clear, though, Mr. Nelson, I understand you've requested both audio and video record the proceedings. That is specifically denied. I understand you'll take exceptions to my ruling. That's perfectly fine. But I want to be clear going forward. I've allowed most all of your requests, which I think are all fine, given your circumstances and requests. All right, so when you're situated, have a seat. Ready?
Yes, sir.
Okay. However, I just want to be clear. There are no audio or video recordings. I understand you disagree with my ruling. That's fine, but do you understand my ruling? To have no video or audio recordings of the matter.
I understand that's the court's position. I think I have a motion to dismiss on that matter, Judge.
Sure. I'll hear from you at the appropriate time. Right now, it's not yet. I just want to make sure you understand and will comply with my order. I understand you don't agree with it. I understand you object to it. But I'm not letting you video or audio record anything here in court. You understand?
I hear what you're saying, Judge.
Okay, and I'm not trying to get you to waive any objection. I just want to make sure we're communicating correctly. Even if we disagree with each other, I want to make sure we're communicating directly. I have allowed you to use your cell phone, but only in terms of reviewing documents. You're not to record or video anything on your cell phone. Do you understand?
Yes, Judge. As far as I know, with documents, I plan on submitting documents for your consideration and to pass to the prosecution via my phone. That way I can verify it is the document I intend to pass up.
You need to print off either a hard copy. I'll give you time today to print off a hard copy or something else that's going to need to be included for the record. We're not going to take your cell phone. I don't think you want us taking your cell phone. I need a hard copy printed off for the record so that you preserve the record as to whatever it is you intend to admit. It's got to be preserved by the clerk. That's not anything to pick on you. That's how it is in every case. So I'll need a printed copy. Otherwise, there's no way to retain what you've offered into evidence, and that would be to your detriment. I'm not trying to do that.
I understand that, Judge. I have emails already drafted, ready to submit to Ms. Redd and the prosecution, and their attachments in a format that I can read. If I print it out paper to hand to the court, I can't read it myself and verify it is what I intend to pass up to the court.
Well, print off whatever you want to print off from your printer. That's fine, and bring it here so that you're clear that's what you want, okay?
This, Judge, this goes into the nature of my motion to dismiss. I can't read printed material, so I would require a visual interpreter to translate whatever's printed.
Sir, you have a personal assistant that will be able to do that. That's why I brought him here. Who is with you today, please?
I'm William Simmons.
Okay, Mr. Simmons, thank you. You look very professional. I appreciate you being here. Are you an attorney?
Yes, sir. I do federal law.
Okay, William Simmons, are you licensed to practice in the state of North Carolina?
South Carolina, and federal bar in the course of.
I appreciate your straightforwardness. So, Mr. Simmons, you hold yourself out as an attorney. When were you licensed to practice law?
1997, maybe 1992, somewhere around.
You don't know when you were licensed to practice law?
Yeah, I think it was 97. I can't remember, to be honest.
All right. And you say in 97, is that when you were admitted to practice in South Carolina?
I was admitted to practice in South Carolina.
So when I check the South Carolina State Bar website, they're going to show you it being admitted to practice in or around 1997?
Yes, Your Honor. And my bar number is 15882.
15882. Mr. Simmons, thank you very much. You're being admitted. I'm going to go through all the requests Mr. Nelson had, and we're going to have, I understand, some pretrial motions. That's perfectly fine. Mr. Simmons, you're here. I'm going to give you a lot of leeway. So you're an attorney. You know how court procedures work. I'm going to allow you to describe anything Mr. Nelson needs you to describe and to read to him, and anything needs to be read. We'll take as much time as it needs that we need to do. You understand my concern about needing to print everything off for the clerk to be kept. I have no idea what's going to happen in the trial of the matter of this. If it becomes the subject of appellate review, and I'm looking at my crystal ball and guessing as to what may or may not happen, the only way to know on the front end is to make sure it's marked with the defendant's exhibit number and offered into evidence at the appropriate time. We're not going to start the jury trial today. There's going to be ample time for you and Mr. Nelson to make sure anything he wants printed off is printed off, where you can read to him anything that needs to be read, so both of you can be certain that is what he intends to offer. And we can talk about it when he makes the offer. If there's an objection from the state, I'll have to make a ruling on it, and we'll go from there. I'm not ordering this. I'm simply asking this. Mr. Simmons, if you could, as assisting Mr. Nelson, if you could print off however many exhibits you think are going to be necessary, that's fine. If you could pre-number defense exhibits 1 through whatever, that would be great. You don't have to. It would just, in my experience in trying cases, when numbers, even if you have 100, if they're pre-numbered, it makes it easier. You don't have to go in order. For instance, if you decide based on trial strategy considerations not to offer defense exhibit number 5 or 6, just skip it. Then you go defense exhibits 1, 2, 3, 4, skip 5 and 6, the next one will be 7. It's not necessary that they all be in order based on fluid trial strategy considerations. You never know what the state may or may not do or how the evidence plays out. But Mr. Simmons, if you understand my humble request.
Yes, Your Honor, and I'll do it. As a matter of fact,
Judge, I have this in my notes, but I can refer to it. I believe it's there's a federal law with the ADA specifically talking about a public entity can't force an individual to bring another individual to interpret for him or her.
I'm not forcing you to do that. You asked to do that, and I allowed you to do that, sir.
No, sir. I did not ask for my auxiliary aide to be my interpreter. I've asked the court to provide an interpreter, and that's part of the motion to dismiss.
There is no, I checked with the administrative office of the courts, and there is no such certified visual interpreter that they can find or determine. Therefore, without a certified visual interpreter, you will not be provided someone who simply says they can do it. They are in no better position than anyone else. Without a certification process, that person's in no better position than Mr. Simmons. So Mr. Simmons, at your choosing, he is your personal assistant. You've asked to bring him. He's here. Mr. Simmons, I'm allowing you to do that. You don't have to do anything. You and Mr. Nelson don't want to do it, but I'm giving you that opportunity. So what I'm going to do is this. I'm going to hear from you later, Mr. Nelson, about your pretrial motions to dismiss. In the meantime, Mr. Simmons, as his personal representative to Mr. Nelson, I want the state and Mr. Cochran, were you the DA that represented the state in district court?
Mr. Hux is the one that handled the case in district court.
Mr. Hux?
Jeff Hux.
Okay. I want to hear from Mr. Hux later today. What I'd like to do is this. I'm going to hold this matter open. I want you, on behalf of the state, to meet with Mr. Nelson and Mr. Simmons to publish to Mr. Nelson all exhibits you believe the state will be relying on. Do you have any exhibits in this case?
Yeah, the only 2 exhibits I will have, other than the body cam, is I've got 2 Google Map pictures of the area.
All right, you have 2 Google Map pictures. And please note, Mr. Nelson, I never do this in any other trial. This is very unusual. However, it doesn't offend me at all. We have time, and I'm giving you, unlike I would have given any other defendant, I'm requiring the state to show you in advance of trial all the known exhibits the state reasonably believes to be offered. It doesn't mean they will, but I'm giving you the opportunity to review with your assistant all the exhibits. That's all you're doing. You're not agreeing that they're admissible or anything else. I want to make sure you're aware of them. Nothing more, nothing less, okay? So, Mr. Kaufman, so you have 2 Google Maps, is that right?
Yes, sir.
And you have 2 body-worn cameras, body-worn camera footage.
I have body-worn camera footage and dash cam footage, and then I've got a flash drive of the YouTube video that Mr. Nelson posted on YouTube after the incident occurred.
YouTube video from the defendant?
Yes.
Okay, so how many body-worn camera videos do you have?
Yeah, I've got 3 discs.
Now, I want to know, I'm trying to identify for the record how many videos we have. You said disc, talking in my term, how many body-worn camera videos do you have? Not discs, because I don't know what's on a disc.
There are 4 individual videos on 1 disc. There are 2, and that's Benfield body cam, Benfield dash cam. There are 2 videos, and
So you said there are 4 videos, then you said there are 2 videos. How many videos are there? I'm trying to understand.
there's probably, I think there's 7 total videos across all my discs.
Do you think or do you know?
I'm 99% sure.
All right, 7 videos on how many different discs?
3 discs. And then I have a separate flash drive that has 1 video.
7 videos on 3 discs. All right. How long will all 7 of those videos last if you were to play them from start to finish? Approximately how long?
It will probably be approximately about 3 hours.
All right. And the Google Maps, I assume there's nothing you'd be able to publish that to Mr. Nelson, and that just takes a chance for him and his assistant to review those and go from there.
I mean, I've got copies right now. I'm happy to go ahead and hand him copies.
Do you have copies for the defendant to have?
Yes, sir.
Okay, that's fine if you have that. What I want you to do is go to the auxiliary room and take a look at all the videos. Mr. Nelson, you don't have to look at them. You don't have to review them with your assistant, Mr. Simmons. But I'm giving you the opportunity to do that in advance of trial. I don't know, I'm going to ask Mr. Hucks what was published in district court. I understand this is a de novo hearing, that's perfectly fine. But what I want to do is to make sure that you've had a chance to review all purported videos. Let the record reflect that Mr. Kaufman has just given Mr. Simmons the 2 Google Maps the state may identify as an exhibit and offer in the trial. Mr. Simmons, Mr. Nelson, those are your copies of the Google Maps. I am going to order, understanding, Mr. Nelson, that you publish things on YouTube. I'm going to restrict anybody from publishing anything about this case on any type of social media account, YouTube, Facebook, or any other time until the trial's over with. Do you understand for the state?
Yes, sir.
Do you understand, Mr. Nelson?
There's a lot there, Judge.
Don't publish anything on social media about this trial until it's over with. Do you understand?
Okay, I hear you.
Okay, there's not a lot there. Do you understand that?
With that aspect, yes. But
Okay,
as
that's
far as
fine.
the video,
So what I want you to do, don't publish anything about this trial starting right now. Don't publish anything on any type of social media or anywhere else. I don't want to try this case in the media. I want to try it in the courtroom, nowhere else, just like I would in any other case. Now, Mr. Nelson, you asked to wear dark sunglasses. You're not wearing them in any other case. Now, Mr. Nelson, you asked to wear dark sunglasses. You're not wearing dark sunglasses. You're wearing a blindfold. Have you changed your request?
No, I am wearing dark sunglasses.
Well, then you don't need to wear a blindfold. You need to simply wear dark sunglasses. That's more than adequate. You'll need to take your blindfold off.
Judge, the lights in here are brighter than I realized.
Sir, this is nothing more than theatrics. You can take your blindfold off and wear your dark sunglasses. I think it's theatrical.
With all due respect, Judge, I have medical conditions that make it
And you may wear your dark
extremely sensitive to light.
sunglasses. You may wear your dark sunglasses. You will take your blindfold off, okay? I think that's theatrical. You've asked me in written correspondence to have everyone blindfolded in this case. You may wear your dark sunglasses and your hat. I have not restricted anybody else from doing that, but you need to take your blindfold off, okay? So what I'm going to do, take your blindfold off, sir.
Yeah, Mr. Nelson and Simmons, that everybody agreed that threats would not be used in court.
Say that one more time.
Mr. Nelson was signaling to me that to remind the court that threats would not be used against him.
And threats are not used against him. He's not going to be able to simply change what he's requested or to dictate to the court how the case is going to be tried. It's not a threat, it's a direct request. It'll soon become an order to take his blindfold off. Sir, take your blindfold off, please. It's not a threat. I use the word please.
Okay, sir, this is an ADA request for reasonable accommodation based on this new information that I have today that the lights are brighter than I anticipated. I had no way to know how bright the lights were going to be, and so I got here today. I didn't, in fact, put the blindfold on until we came in and sat and realized that it's extremely bright in this room. If we could lower the lights, Judge, then the blindfold can come off. This is for my ability to communicate with the court effectively. So it's an ADA request for reasonable modification for effective communication, to be able to not have a migraine during the pre-trial hearing or trial or at any point during the court proceedings.
Well, I certainly don't want you to have a migraine through any point in the proceedings. See what you can do about getting your sunglasses or making other modifications. What I'm going to do is I'll excuse all of y'all to the jury assembly room to view the state's 7 videos. Mr. Cochran, I'm going to want you to put on the record at a later time exactly. Now, I want to know with 100% specificity what videos are on the 3 discs. I want them published to Mr. Nelson at this time so he's aware well in advance of trial of all potential exhibits. At this time, do you anticipate offering all 7 videos into evidence?
No, Your Honor.
Which ones do you anticipate offering into evidence?
Yeah, I would anticipate offering Benfield's body cam, which is the 4 videos, Benfield's dash cam, there's 2 videos, and the flash drive with Mr. Nelson's own video that he posted on YouTube.
Okay, so Mr. Nelson, did you what the state just said?
I did, Judge, and I have no way to interpret those videos without a visual interpreter.
Okay, and you have Mr. Nelson with you. What I'm going to do is let all of you go into the other room and make sure, is there audio on the video?
Yes, sir.
Video, all right, make sure the audio is turned up to Mr. Nelson's satisfaction. I'm going to let all of you go to the jury room to review those, take as much time as you need. Mr. Nelson, I'm also going to provide you with recordings, sound recordings each day, and I can do that on, it doesn't have to be daily, I can do it twice a day if you'd like it, of the proceedings that take place here in the courtroom. The court reporter informs me she has a DVD that would burn to a DVD. Do you understand?
Yes, Judge, as part of my motion to dismiss, there's a due process concern I have, even as we speak, Judge, that I don't have the ability to take notes and what's happening currently, whereas the prosecution can. And for me to be able to have real-time notes is a crucial element in due process in a trial. So if I have to wait to the end of the day to get notes, I request if that's what you're ordering upon me, that you order the prosecution also to not be able to write any notes in any fashion, that he has to get his notes from the court reporter at the end of the day as well.
At this point, I'm not going to take that advice. We're not hearing pre-trial motions, Mr. Nelson. I'll hear from you at some point. But the point of allowing you, unlike I would in any other case, to see all possible exhibits that the state may offer and understand, without knowing what the defense evidence may be, the state doesn't know if it'll offer all 7 videos, but it's indicating only 3 videos. Take a listen to all the videos. You have your personal assistant, if you're choosing, that can assist you in any way he needs to do to review the videos. Take as many notes as you need. You can play the videos on more than one occasion. We are not starting this jury trial today. I'll hear back from you. I have another civil hearing at 2 o'clock. What I'll do is hear back from you all at 3 o'clock. Take as much time as you need. Be sure to take a lunch recess. Mr. Cochran worked with Mr. Nelson and his personal assistant, Mr. Simmons, or not personal assistant, but his assistant in this case, Mr. Simmons. And Mr. Simmons, I know because you're not licensed in North Carolina, I'm allowing you to come in here as to assist Mr. Nelson in ways both you and he deem appropriate, but you can't give legal advice in a North Carolina case. I know you know that as a licensed attorney, so it's your duty's a little bit different here than it would be, say, in South Carolina. Do you understand?
Yes, sir.
Can you comply with that request?
Yes, sir.
In order? Okay. Then at this time, Mr. Nelson and Mr. Simmons, if you'll please walk over here. That's the jury deliberation room. Take as much time as you need to review everything. When I hear back from you 3, we'll go from there. And Mr. Simmons, I'm also going to give you this waiver of counsel. Mr. Nelson, I know that you reviewed everything and had a WebEx hearing with Judge Wilson, I think it was last week, regarding your decision to represent yourself. I'm going to give you a waiver of counsel. I'm still going to go through this. I understand you want to represent yourself, but don't want to waive anything. Is that still accurate?
Yes, Judge. I think that was on the 11th we had the hearing.
Yes, sir. I'm going to give a waiver of counsel to Mr. Simmons. Mr. Simmons, if you'll go over this with your client, I intend to go over box number 2, and I circled it. And this is your copy, not mine. Sheriff, you give this to Mr. Simmons. I intend to ask him, Mr. Simmons, as you know, Mr. Nelson has a right to represent himself. What? Excuse me?
I'm sorry, he doesn't want me to accept that.
Don't have a choice. You're here on his behalf. I'm giving it to you. I'm not.
With all due respect, Judge, he's not here on my behalf. He's not representing me. I'm representing myself. He's my auxiliary aide, so he works at my
Sheriff, give that to
assistant.
Mr. Nelson. Give that to Mr. Nelson, it's fine.
I can't read whatever paper you're handing me, Judge. I can't accept that.
Okay, that's fine, I'm still giving it to you, please
If
take
you
it.
could send it to me in an OCR format, I believe that was one of the
I'm
accommodations you
giving it to
agreed
you
to.
right now. Mr. Nelson, I'm giving it to you right now. Take it with Mr. Simmons, and I'll do the best I can to get it to you in another way. Take it, please.
Judge,
Wait a minute. Do you refuse to take that document?
we had an agreement, Judge, that you would send documents to me in OCR compatible format, and that's,
With exhibits, sir.
with anything, Judge. I can't read physical paper. That was what my request was for. All
Give it to
documents
Mr.
to be
Simmons.
sent to me in
Give it to
OCR
Mr.
format.
Simmons. Mr. Simmons, review that document. You're here by order to review that document, Mr. Nelson. All you take, go to the jury room to review the exhibits. Thank you very much. Thank you, sir. Thank you. Gentlemen, go to the jury room, please. Let the record reflect that Mr. Nelson refused to accept the waiver of counsel form as blank. There's nothing done on it. I simply gave it to him as a courtesy. He refused to accept it. So I gave it to his personal assistant that he chose to bring to the courtroom to assist him in this case.
Be quiet,
Yes.
I'm talking to you.
Hey, gentlemen, just go to the jury room, please.
John, if I may.
Sir, Lieutenant Jack, will you please stand up and identify yourself or on the record?
Why?
Because I asked you to. I need to know who's in the courtroom.
You do?
Yes.
For what purpose?
There have been threats to other deputies in connection with Mr. Nelson's case. I want to make sure I know who's in the courtroom. Please state your name.
So, Your Honor, you're
Sir, I'm asking you to state your name for the record.
saying that I threatened the deputy?
No, sir, I'm not. I'm controlling the courtroom.
Did you ask anybody
Tell
else
me
in
your
this
name.
room who, with their names?
Sir, tell me your name.
Your Honor, did you ask anybody else?
You're here by, let the record reflect, he is evicted from the courtroom. Sheriff, escort him out of the courtroom. You've refused to answer simple questions. You will not be permitted in the trial. You're disrupting court. Evicted from the courthouse. Tell him to take him from the courthouse. He's causing a disruption. He refuses to identify who he is. He doesn't need to be here. Sir, you're evicted from the courtroom. If you want to tell me who you are, I'll gladly listen to you.
No, did you ask anybody else in the courtroom?
Yes, I've identified everybody else. Please leave the courtroom, sir.
Yes or no? I didn't hear you.
I've identified everybody else. Sheriff, have him leave the courthouse now. Let the record reflect he's being combative with the court. The tone of his voice was very argumentative and agitated. Gentlemen, tell me your name back in the right corner of the courtroom.
Kyle Ray.
Kyle Ray?
Yes, sir.
Okay, tell me your purpose of being here. Forgive me, I don't know until I ask.
Yes, sir. I'm a witness for the state.
Okay, that's fine. You're welcome to be here. You've acted absolutely just fine. Tell me your name, sir.
Sergeant Clayton Dawson with the Madison Police Department.
All right.
Witness on the state.
I understand. Tell me your name, sir.
Keith McPhail. I'm here with the state.
All right, I understand. I've already identified everybody else in any event. All right.
Up next is the recording of the afternoon session.
I'm just telling you. Let's come back to order in the State versus Nelson case, please. I'll see you in just a second.
I'll try to do partially anyway, and I can do it.
work for your situation?
I didn't hear that, Judge.
Sure, I got my mask on. Hold. The lights have been dimmed significantly from when you were in last. At your request, and on further consideration, I asked the lights to be dimmed. I can still see everybody in the courtroom. There are a lot of shadows in the courtroom now. I don't want to go low to this, but my question is, will this work for your situation?
Yeah, I noticed immediately when I came in during this other pre-trial.
Okay.
Greatly appreciate it. Thank you, Judge.
Okay, that's not a problem. Any other time something comes up, just alert me, and just through you or your hard-working personal assistant, let me know. Forgive me, Mr. Simmons, if I call you an assistant and that offends you. I'm not trying to offend you. That's just what you're identified in any event. And I will gladly at least consider it. If I can work with you, I will. Y'all have been here. I appreciate your patience. We've been at this for an hour and almost 40 minutes. I need to give the courtroom personnel a break. I haven't done that. I want to get you up here. So we're going to take a 15-minute recess. And there are quite a few issues. I'm not sure. I don't think we're going to get finished with the pretrial issues today based on what I'm assessing the number to be. But as soon as we get back, I'll start. We'll get as far as we can get. And I'm not sure we'll be able to call the jury in tomorrow. It may need to be Wednesday. We'll just see where we are at the end of the day and go from there, okay? Sheriff, we're in recess for, everyone's welcome to stay in the courtroom, but you don't have to. Just be back in 15 minutes. We're in recess 15 minutes.
Well, then recess 15 minutes.
All right, thank y'all for your patience. Let the record reflect. This is Judge Albright, and I have Mr. Nelson in the courtroom along with his assistant, Mr. William Simmons. There are quite a few pretrial matters that we need to discuss. It's going to take a little while. Give me just a second. We've already addressed the lights issue. All right, let me address the attorney issue. Mr. Nelson, I've looked through the file. I had a chance to do that in more detail over lunch. I see where you have talked to Judge Allen. The date that I have is back on November 8th of 2021. And during that time, there was a motion to withdraw by Mr. Holt, and you did not agree to waive your right to all counsel to represent yourself, but you also didn't hire another attorney. Judge Allen took no action. He simply held the matter open for a later date. That was revisited by Judge Wilson on or about January 11th, 2022. So that would be last week. That would be 2 weeks ago, where he talked to you and went through a colloquy. I have a transcript from that, and went through a colloquy, and ultimately you told him you wanted to represent yourself, but you didn't want to waive anything at all, and that's sort of where you left it. Has anything changed with regard to your position with regard to Judge Allen or Judge Wilson about your desire to represent yourself but not going to waive anything?
Negative, Judge. The only, I guess, note I have was...
And if you would, Mr. Nelson, it's no reflection on you. Mr. Simmons, could you just move that microphone a little bit? Just bend it. It bends. Just bend it towards them. That's fine. I'm not saying I can't hear well.
Do I need to direct my voice that way?
No, that's all right. The microphone is moved in front of you, and I'm trying to talk in mine just so I can hear me. When my mask on, it's going to be harder. Go ahead.
On the 11th, I believe it was Judge Wilson directed Attorney Graham Holt to put his withdrawal in an order and,
yes.
and to have me review it and approve it. Mr. Holt sent me what he had, I believe like a few days later, and I told him I was not comfortable with what he had in that and to correct something. And that's the last correspondence I had with Mr. Holt. I tried to get contact with him. And the last I heard, I think this morning from the Madam Clerk, was that Mr. Holt filed something anyway without my...
Well, he didn't. Judge Wilson entered an order based on his motion to withdraw from representing you. Judge Wilson found that there was good cause shown and it should be allowed, and therefore he allowed him to withdraw his counsel for you as a record attorney in this matter and relieved him of all further duties. And I understand from looking at the the hearing transcript from your WebEx hearing with Judge Wilson on January 11th, you indicated that you had fired Mr. Holt last year in 2021 at some point. Is that right?
That's correct, Judge. And I corrected, I think I misspoke. It wasn't a motion, it was the order. I think Mr. Holt asked if he could write the order, and then Judge Wilson instructed Mr. Holt to run whatever verbiage was in that order by me, make sure I got my approval since I'm representing myself, and there was a correction, and I never heard back from that. So whatever Mr. Holt submitted to the judge to be the order was never approved as per the direction of the court.
Understood. I'm telling you, Judge Wilson entered an order. He entered two orders. One, it was typed up by the clerk at Judge Wilson's direction. And then the other one, the short order basically is redundant. It says the same thing, but in less words. Long story short, Mr. Holt's no longer your attorney. He was allowed to withdraw based on both his motion and your statement that you had fired him as of last year. Do you remember when last year that you officially fired him?
Not the exact date. I can find the email. It was December before Christmas sometime. At least a week. Yeah.
Sorry.
Mid-December.
Go ahead.
Maybe mid-December, Judge.
So if I said approximately mid-December of 2021, would that be accurate?
Absolutely.
All right, hold on a second. All right, Mr. Nelson, any objection? And I understand the waiver of counsel, in addition to giving to Mr. Simmons, I also attempted to have Ms. Reb send it to you by email using the appropriate email, however they've been communicating to you in the past. Not for your anything other than just say this is what we'll be working off of with regard to the attorney issue. I'd like to go revisit everything that Judge Wilson did, if you don't mind. Similar questions about your decision to represent yourself, and your answers will be what your answers will be. I'm not trying to get you to do anything other than just go over it. Since I wasn't the one there with Judge Allen, that was Judge Allen. Obviously, I'm not Judge Wilson. I want to do the same thing, and then I will make some findings on that and we can proceed. All right, do you understand?
Yes, Judge, my answer is going to be the same as it was on the 11th.
Okay, then this will make it real quick. Let me ask you this. Can I have you sworn, or do you want to be affirmed? Either way.
I'll affirm.
If you'll just raise your right hand. Please have affirmed. Just raise your right hand, please.
Okay. Put it over my heart.
All right, it's raised. Will you please affirm Mr. Nelson to give me truthful answers?
Yes.
And wait, she's gonna say it.
Do you affirm to give the judge truthful answers?
Yes.
This is your solemn affirmation.
All right, thank you. You can put your hand down, Mr. Nelson. I appreciate it. All right, so you are Michael Paul Nelson, is that right?
Yes.
All right, sir, are you able to hear and understand me at this time?
Yes.
As you stand here right now, are you under the influence of alcohol, drugs, narcotics, medicines, pills, or any other such substances?
Some vitamins, I believe, Judge.
All right. Did the vitamins in any way prevent you from understanding any of my questions, or prevent you from being here today, or in any way interfere with your ability to represent yourself in this case?
No.
All right. How old are you, sir, approximately?
Approximately 38.
All right. What's the highest grade level of schooling that you completed?
Bachelor's degree.
Then, to state the obvious, you obviously know how to read and write. And I understand you have a visual limitation at this point, but you do know how to read and write.
I was instructed on how to read and write with my eyes, and have been re-instructed by the Department of Veterans Affairs blind rehab centers on how to use assistive technology to read with a screen reader and a headset.
Understood. Mr. Nelson, as you're standing here right now, do you suffer from a mental or physical handicap that would prevent you from understanding any of my questions?
As long as I'm not being threatened, then no. If I'm being threatened, then it does limit my ability to understand.
No, I'm not threatening you. I haven't threatened you now, nor have I threatened you at all. Let me ask you this. Do you suffer from any mental or physical handicap that would prevent you from understanding the nature of the proceedings here against you?
It's the same answer, Judge.
So in other words, do you understand the nature of the proceedings here against you then?
Currently, yes.
All right. Do you understand, Mr. Nelson, and again, I understand you're not going to waive any of your rights, but do you understand you do have the right to be represented by an attorney?
Yes.
Do you also understand if you want me to appoint a court-appointed attorney for you, all you have to do is ask
Yes.
if you qualify for it? You understand that?
Yes.
Do you also understand, Mr. Nelson, much like Judge Wilson advised you on January 11th, that if you decide to represent yourself, you must follow the same rules of evidence and procedure that an attorney appearing in this courtroom must follow?
Yes.
Do you understand, sir, if you decide to represent yourself, the court, that's me, the judge, will not give you any legal advice concerning any defenses or jury instructions or other legal issues that may arise during the course of your trial if we get to your trial?
Yes.
Do you understand that I'm going to act as an impartial judge in this case, and once again, I'll not be able to offer you any legal advice. I'm going to treat you just as I would treat an attorney appearing in this court?
Yes, I hope so.
Sorry, that's a little redundant, I understand. Hold on a second. And do you understand, sir, that you're charged with one count of resisting a public officer? That's a class 2 misdemeanor. And depending on your prior record level, the maximum term of imprisonment, again, it depends on your prior record level, will be 60 days in jail.
Yes, Judge, I have no record.
I understand. If you have no record, then the stiffest sentence you can get is a probationary sentence. You understand that?
Yes, Judge.
All right. Considering all the questions I've asked you, do you have any questions for me about your decision to represent yourself?
I think there was a. You said you would treat me the same as the other attorneys.
I'm going to treat you like I would any other attorney, except we'll go through all of your requests with regard to the Americans with Disability Act in a minute. So I'm actually I'm giving you more considerations than I would an attorney appearing in this court. But with regard to legal implications, I'm going to treat you like I would an attorney. I'm not going to be for or against you. I'm simply going to ask the same question I would ask an attorney, and you're going to have to give me the answer. And if you want me to give you advice, I can't do that. I'm not allowed to give you legal advice. I'm not going to give the state legal advice, just as I would any other attorney. You understand?
Thanks for that clarification. Yes, Judge.
You have any other questions for me?
No.
All right. Is it now your desire, do you want to represent yourself?
Yes.
In this case, do you want a court-appointed attorney?
No.
Do you want to hire your own attorney?
No.
All right. Here's what I'm going to find. Mr. Nelson, object if you find any objection, okay? And you may sit down, sir. Thank you. Court finds that Mr. Nelson has been fully informed of the charge against him, the nature of and the statutory punishment for each charge, the nature of the proceeding against him, and his right to have counsel assigned by the court, as well as his right to have the assistance of counsel to represent him in this matter. The court further finds that the defendant comprehends the nature of the charge and the proceedings, the range of punishments, that he understands and appreciates the consequences of his decision, and that the defendant has voluntarily, knowingly, and intelligently elected an open court to be tried in this case without the assistance of counsel, which includes the right to assign counsel and the right to assistant counsel. Any objection to any of those findings, Mr. Nelson?
I think the assistance of counsel. The assistance of counsel. I think you asked me if I.
You don't want to be. You want to represent yourself in this case.
Right.
That means you don't get an attorney. And Mr. Simmons, while he's an attorney, he's going to be here with you, but he's not representing you in his attorney capacity.
Yes, Judge. My understanding is assistant counsel from the Constitution doesn't specify whether it's an attorney or not. So I don't want to. I want to make sure that the verbiage is clear. That I still may rely on counsel, but not legal advice from an attorney.
Okay, I'm restricting all of this to attorneys only.
Okay.
Any objection to the findings when it's restricted to either court-appointed counsel or your own hired private attorney?
No objection.
All right. And based on your previous discussions and hearings with Judge Allen and Judge Wilson, will you sign a written waiver to that effect or not?
No, Judge, I will not.
I understand. And here's what I'm doing. Just a minute. judge made the findings that I've made. I understand the defendant has refused to sign the waiver of counsel. I'm going to enter that in just a second. All right, again, the court finds that I've made all the findings that were entered. The record reflects what I found and Mr. Nelson's response to it. The court also finds, and I've already mentioned this, that on November 8, 2021, Judge Allen had a hearing. The order in the file reads it was by WebEx with Mr. Nelson and his then attorney, Graham Holt, regarding Mr. Holt's motion to withdraw. And the court specifically found that he's not ruling on that motion to withdraw at that time because the defendant did not have a new attorney and was not waiving his right to represent himself. Well, it says not waiving to represent himself, but it was uncertain as to what the defendant wanted to do. Therefore, flash forward again to January 11th of 2022. And again, Mr. Nelson had a hearing, again by WebEx with Judge Wilson. Graham Holt, his then attorney, was also part of the hearing at that time. Judge Wilson ultimately allowed Graham Holt's motion to withdraw. And during the course of that hearing, Mr. Nelson didn't want Mr. Holt as his attorney anyway, because he had fired him approximately in mid-December of 2021, and that transcript from January 11th of 2022 speaks for itself. But Judge Wilson went through not quite identical, but very similar questions to the ones that I just went through with Mr. Nelson, and Mr. Nelson unequivocally stated he wanted to represent himself and that he was not otherwise waiving any rights. And flash forward now from January 11th, it is almost 2 weeks later, and Mr. Nelson's answers, as he told me they would be, are almost identical to what he told Judge Wilson. He unequivocally told me that he wants to represent himself, that he doesn't want to hire an attorney, and he doesn't want to ask for a court-appointed attorney. He's here to represent himself. The court finds, in the alternative, the court first found that he waived his right to all counsel and wants to represent himself. Given the defendant's answers, which are somewhat contradictory in that he wants to represent himself, but doesn't want to waive any right to court-appointed counsel or the hiring his own attorney, the court's going to find that in the alternative, he's forfeited his right to counsel, because we're going to proceed with this case. Presumably, we're going to proceed with this case this week, and he doesn't have an attorney, and has articulated no desire to hire his own attorney. So I'm making both of those findings in the alternative. And I'll give the clerk that waiver of counsel form that I've executed to be file stamped and maintained with the file, please. If you'll please make an extra copy just for, I will provide that to the defendant either today or tomorrow. All right. We have Detective Doom, Officer Doom, Sergeant Doom, Sergeant Captain? Sergeant, I'm sorry. If I could please, if you'll hold the Bible in your left hand, there should be one over there. If you'll hold the Bible in your left hand, raise your right hand, and have sworn to give the court truthful answers.
You solemnly swear the information you shall give to the court shall be the truth, the whole truth, and nothing but the truth, so help God?
Yes. All right, Sergeant, if you'll just state your name for the record, please.
Sergeant Jason Doom.
All right, Sergeant Doom, could you, are you familiar with Mr. Michael Nelson being in court before, the defendant in this case?
Yes, sir.
All right, this is a DWI appeal. excuse me, it's not a DWI appeal, it's a misdemeanor appeal, resisting, obstructing, delaying charge, resisting public officer. Could you please tell us about any security issues you've had during the course of this case since it's been in district court up to today's date? I'm not saying just about the previous trial, this is certainly a de novo hearing. However, can you tell me about any security issues that you need to tell me about? We're here on the record.
Yes, on October 6th, we, with his very first court appearance.
October 6th of 2021. 2020. I'm sorry, okay?
There were several people that were here protesting this case.
They were here on behalf.
They were just here on behalf of
just for Mr. Nelson.
Yes, just
all right.
Objection, speculation.
That's all right, Mr. Nelson. I'm not finding that you had anything to do with them being here. I'm not finding that you asked them to be here. I'm just asking the sheriff to tell me what he believes are security issues that I need to know about. Go ahead.
Well, I believe he's speculating, Judge. He has no idea why he's able to do what they did.
All right. What were they here for, Sheriff? What were they doing?
They were here to protest.
What were they protesting?
It was court day.
You mean this?
Yeah, the fact that we were not allowing him to have his recording devices in the courthouse.
Okay. So they were upset that Mr. Nelson was being prosecuted?
Yes.
So what else happened during the course of that?
Throughout the day, the people involved were belligerent, started making threats.
What kind of threats?
The ones here didn't really make any threats, but this was a worldwide deal. And some threats came in through the sheriff's office that some of us would be shot later that day.
As a result of the hearing involving Mr. Nelson?
Well, the fact we shot later that day.
As a result of the hearing involving Mr. Nelson?
Well, the fact that he did not go to the courthouse for the hearing because he did not want we would not allow him to have his electronic devices in here. So he was placed under arrest for failure to appear, issued by Judge Albright.
All right. I'm glad no one made good on the threats.
I am too.
All right. Anything else in connection with Mr. Nelson's case that you think I need to know about that relates to courtroom security?
Just that, anybody comes in needs to be identified.
Well, tell me about, did you notice anything this morning?
This morning there was a gentleman that was, in fact, involved in that protest that day, came in this morning.
So you came back from October 6th of 2020?
Yes.
Did you recognize that person when he came in from October 6th of 2020?
Yes.
All right. What did you see him in here doing?
He came in, he sat down, and as you were speaking with Mr. Nelson, he would shake his head, throw his hands about as if he did not agree with what you were telling Mr. Nelson.
All right. And at some point you relayed that same information to me at the bench, is that correct?
Yes, sir.
All right. Mr. Nelson, I don't believe you were in the courtroom at the time, but I asked the gentleman simply to stand up as I would in any case when it's brought to my attention that there could be a courthouse security issue. I don't have a crystal ball. The only way I know how to find out if something's going on is to ask. I asked the gentleman to stand up. He complied with that. Then I asked him to tell me his name. I don't have a crystal ball. I don't know what his name is. He refused to tell me his name. I don't find as a fact that he was here on your behalf. I don't know that to be a fact. But I know that he was belligerent. He was aggressive with me and very confrontational. So I excused him from the courtroom, and I could see him back at the back of the courtroom. He was trying to get back in, and he was gesturing. There were menacing gestures towards the court so that I evicted him from the courthouse. I do not know if he was with you or not, but I wanted to let both parties know that that was done. As a result of that, it's rare that that's ever happened in any courtrooms I've been in. It is concerning to the court as it should be. I don't want someone here trying to do anything to the state or to you, Mr. Nelson. I don't know if he was here to hurt you or what. I don't know why he was here. But I asked him to leave and ordered him to leave, and he's gone. As a result of other issues that Sergeant Doom's just related to me, because I don't want people coming in on either side, hurting either party at either table here. I've ordered the sheriff, as I'm allowed to do, to control courtroom proceedings, to have anyone that comes into court identify themselves if the sheriff doesn't already know, and tell me the purpose for which they're being here. It's an open courtroom. Anybody's allowed to be here, but I'm restricting the courtroom access to those folks that can be identified and give you a reason why they're here. A reason simply to watch is a valid reason to be here. The reason's not in and of itself going to be dispositive of letting somebody in or out. A lot of times I have people coming into the courtroom that simply found the wrong courtroom. There's more than one courtroom here in Rockingham County, and oftentimes, regretfully, they come in here, they being just some bystander or defendant in another case comes in here when they're supposed to be on another floor in another courtroom because they were mistaken. They were in this courtroom apparently over the last year or two because of COVID or other issues. But the only thing I've done is to have the sheriff, have anyone coming in to identify themselves and the purpose for being here, okay? State understand what I've done.
Yes, Your Honor.
I'm not trying to interfere with the state's ability to try the case. If you have a witness that needs to be here, just let them know that's going to happen. All right, Mr. Nelson, do you understand what I've done and the reasons why I've done it?
I just don't understand the identification aspect, Judge. This case revolves around the state agents forcing free people of the country to give identification.
Sure.
So that's to the heart of the matter in this case.
I've done it for courtrooms. It's a little bit different than your situation. We're here in the courtroom. I control the courtroom, and if I have someone that, when I ask them their name, that simply sets them off to be confrontational and agitating, and it looks like to me that they wanted to fight. That concerns me. I don't know if they're here to hurt somebody or not. And again, I'm going to ask, and that's why I've done what I've done for the protection and security of both the state and the defendant. I don't know why they're here, but I'm going to find out. And I'm stuck with their answer. I'm not going to do any, I'm not at this point looking behind what they say, but I'm going to take what they say. But that, Sheriff, you've been doing that since we opened at 2 o'clock, is that correct?
Correct.
You asked the civil attorneys that came in why they were coming. You did the same thing with everybody, is that correct?
That's correct. So
So it applies to everybody, okay? You understand, Mr. Nelson?
I believe so, Judge. I would just respectfully request that order and the orders from this morning be put in written format so I can preserve those for appeal.
Sure. We're on the record, and you'll be given a copy of everything that I'm stating right now. We are on the record as we have been the entire time. And I've articulated the reasons why, and you'll get that on the record, okay?
Okay, thank you, Judge.
And I see absolutely no prejudice to the defendant from entering that order whatsoever, or the state for that matter. And if for some reason, Mr. Nelson, you have a witness, and I'm not saying you're going to have any witnesses, but if you have a witness and there's any problem getting in the court, let me know and I'll revisit the matter. There shouldn't be a problem. I've told you what the procedure is and it applies to everybody, but I in no way want to prevent you from presenting a case if you decide at the appropriate time you want to present witnesses. You understand? If there's any problem with someone getting in the courtroom, let me know.
Okay.
All right, and I'll take it one step at a time. You with me on that?
Yes.
All right. The evidence, Mr. Nelson, were you able to review the discovery identified by Mr. Cochran earlier? The videos, and were you able to listen to them and talk about them to the extent you wanted to with Mr. Simmons?
I was able to review the audio, but not the video, Judge.
I understand. Did you review all the audio?
Yes, I asked the prosecutor for a visual interpreter. He also denied that request.
Okay, you had Mr. Simmons there that could describe anything. I understand that's the same video. Well, let me back up. For the state, on behalf of the state, who prosecuted this case in district court?
Yeah, that'd be Mr. Hooks, who's sitting right beside me.
All right, Mr. Hooks, could you tell me what evidence, if any, was offered in district court by way of live individuals and or exhibits?
Your Honor, as far as the state goes, the civilian witness Kyle Ray was one of our witnesses. Officer Doss, who was here, Officer Benfield, who was also here. As far as video that came in, there was a YouTube video that Mr. Nelson posted. The state admitted that evidence. Mr. Nelson's attorney, as I recall, got in the body cam of Officer Benfield and the dash cam of the same. Your Honor, that is my recollection of it.
So Benfield's body-worn camera and Officer Benfield's dashboard camera?
As I recall, yes, Your Honor.
All right, Mr. Nelson, do you recall the district? I understand this is a no hearing, but for purposes of just making sure that you had a chance to fairly review the evidence, I want to make sure that Mr. Hooks correctly state, to your knowledge, what was admitted in district court. None of it's admitted here. This is none of this has anything to do with the actual trial of this matter, other than your review of the evidence.
Right, Judge. Just a correction. Mr. Hooks said it was my YouTube video, and I wasn't able to authenticate that. But
It was tell me that again. What video?
he said it was my YouTube video, and I was unable to authenticate the video that the prosecutor presented in district court. I don't think anyone.
So you don't know what that video was related to?
I'm sorry?
You don't know what that YouTube video was related to?
No, I couldn't verify that that was a video that I created or that my wife created.
Gotcha.
And as far as being able to review the videos presented in district court, I was also denied I think every accommodation request that I made for district court.
All right. Yes, sir.
Your Honor, on that, certainly Mr. Nelson's attorney knew that he could come and view those videos. And it's my understanding that they did go to the police station to review videos.
Do you have anyone here to speak to that issue?
We do.
Yeah, we have Captain White.
All right, Captain, come stand right beside you.
He's a captain for the Madison Police Department.
All right. Captain, if you would just raise your right hand, please. Have him affirm to give me truthful answers, please.
Do you affirm that the information you shall give to the court to be the truth, whole truth, nothing but the truth, so help you God?
Captain, you state your name for the record, please.
Jason White,
Okay, and where do you work?
the Madison Police Department.
All right, I know those questions, but just for the record, I just want to set the record. Could you please speak to what Mr. Hawks was just talking about?
Yes, sir. Myself and Mr. Nelson had corresponded several times.
And if you would, just talk a little bit slower and a little bit louder. It's no reflection on you, it's just hard to hear.
Yes, sir. Myself and Mr. Nelson had corresponded several times through email, setting up a date and time for him to come by with his attorney, Mr. Holt, to view the videos in question. And we did set that up. It was July the 20th of 2020. Mr. Nelson and Mr. Holt did come to the Madison Police Department together, and were able to view together the video, where they were able to speak and talk, and Mr. Holt was observed the video.
Which videos are you talking about?
This was the actual body cam video and the vehicle dash cam video of Officer Benfield.
So he reviewed, your position is on July 20th, 2020, Mr. Nelson was able to review, along with his attorney at that time, Mr. Holt, both the dash cam and the video cam of specifically Officer Benfield, is that right?
Yes, sir.
Were there any other videos he reviewed?
Not at that time.
All right. Mr. Nelson, if you have any questions for Captain White, you don't have to. If you'd like to, you may ask me.
Sure. Did the Madison Police Department provide a visual interpreter during that?
No, sir.
And I believe that's it.
No.
I wasn't able to take my notes because I think, is it true one of the officers told me that I could not record that review?
The actual video, that is correct.
Okay. All right. So that I was, again, prevented from taking my own notes, and I've asked Mr. Holt for his notes for the case, and he's not provided them to me. That's one of the reasons I fired him, was his lack of understanding of the ADA and lack of advocating for me.
All right.
Yeah, if I may ask Captain White.
Yeah, I'm sorry. Not my oversight. Go ahead.
Captain White, on the day they came to review the video, what accommodations did you make for the defendant?
We had set them up where Mr. Nelson and Mr. Holt could view the video together. They had, he was provided notes where Mr. Holt took notes of the videos that he watched.
Where did you have to set it up?
We set it up in the room right when you walk into the police department, in our waiting room. That's where we set that up to watch. Mr. Nelson did not wish to wear any mask or come into the police department at that time, past the locked viewing area.
I have no further questions.
Wait a minute, Mr. Nelson. Any other questions? There don't have to be. But I'll let the state ask questions. Do you have any other questions based on the state's questions to Captain White? You don't have to. I'm just not trying to prevent you from asking questions in that road.
I'm fine. No questions, Judge.
All right. Captain, thank you. Unless you're part of this case, you're free to stay or you're free to go. Thank you for your time.
Thanks, sir.
Does Mr. Kaufman, I understand trial strategy can change based on people's testimony, but at this point, what, if any, of the videos do you anticipate offering into evidence? And again, I'm not holding you to this because you never know if someone takes the stand or a question is asked on cross-examination that makes something previously you didn't think you were previously going to offer change. You may change the trial strategy based on the testimony, but at this moment in time, which videos do you intend to offer, if any?
Your Honor, at this point, the state intends to enter Officer Benfield's body-worn camera and Officer Benfield's dash cam and Mr. Nelson's YouTube video.
What you at least report to be Mr. Nelson's YouTube?
Yes, sir.
And with those the two videos and the YouTube video, Benfield's body-worn camera, dashboard camera, and YouTube video, those are the same videos that were published in district court?
To my understanding, Mr. Hutch, yes, sir.
All right. All right, court finds that Mr. Nelson has been given the opportunity to review the videos that will be offered into evidence in this case at length, both at the trial of this case. The trial of this case took place looking at the order in this case. It looks like it took place on or about October 23rd of 2020. The videos were first published then in the defendant's presence. The court further finds that on July 20th, 2020, and I should note that the hearing or the trial in district court, the file reflects that, again, Jeffrey Hucks, who just provided information to the court, was the DA in the courtroom, and Graham Holt was the defendant's then attorney who represented the defendant at the district court trial. The court finds as a fact that on July 20th, 2020, the defendant reviewed the videos as identified by Captain White. At the time the defendant was able to review the videos, he was with his then attorney, Mr. Graham Holt. The court then again gave the defendant the same privilege to review all the identical videos again, plus some videos the state doesn't intend to offer. The defendant has listened to all the audio and had his personal assistant with him, Mr. William Simmons, present during the course of the watching the videos today before trial. We have not started trial, and it's unclear whether we can start trial tomorrow because we have quite a few other motions to hear. All right, anything else from the state on that? The court also notes that the court, although I would not have done this in any other case, I'm giving the defendant the very big benefit of knowing exactly what the state's trial strategy is, forcing the state to identify the exhibits it intends to offer in this case well in advance of trial, and also has given to the defendant 2 Google Maps. And past that, I don't know how to identify that the state intends to offer, but otherwise, are there any other exhibits I haven't identified that the state intends to offer at this time?
No, Your Honor.
Again, I'm not holding the state to that. If circumstances change during the course of this trial, I understand that your trial strategy could change. It's impossible to know exactly what happens during the course of that trial. All right, Mr. Nelson, let me come to your requests, what I've allowed and what I've denied. In preparing for trial, Mr. Nelson, how would you describe, so I don't misdescribe, but how would you describe your physical condition? What are your ailments so that I don't misstate what they are? You can't see.
I'm sorry, Judge?
You can't see. You're unable to
Are
see.
you asking me to disclose my medical information, Judge?
Yeah, just not in great detail. You can't see. That is an issue for you. Is that right?
With respect to the court, I can answer questions on what functions I can or cannot perform.
Okay.
So being able to see correct, I am limited in what I can see. I can perceive light and color, but I can't make out shapes or words.
Okay, Mr. Nelson, thank you. That's all. I just wanted you to say it, so I'm not trying to state what you know better than me. All right, court, the defendant has asked for several things in advance of trial last week. I responded to the defendant's request as follows. He wants a visual interpreter in this case. That request was denied. The court conferred with the administrative office of the courts with, hold on 1 second, Miss Lori Cole, Loricole, she's with the North Carolina Judicial Branch, as well as Lynn, C-O-R-R-I-N-E, Lusick, L-U-S-I-C. She also works with the North Carolina Administrative Office of the Courts. I believe she's a Deputy Attorney General, but I'm not positive she's a Deputy Attorney General. Nevertheless, I conferred with them about Mr. Nelson's request, trying to determine what information they can provide so that I can properly and timely rule on his request. And that I learned after speaking with them that there are no certified visual interpreters. Therefore, I have denied Mr. Nelson's request because there are no certified visual interpreters. No one that we bring to court would be in any better position than anybody else to be able to describe to Mr. Nelson what is occurring in this case. I do know that the witnesses, Mr. Nelson already has familiarity with the witnesses. They're the same ones that were already called in the district court case. I further note that among other requests, Mr. Nelson also requested the use of a personal assistant as an auxiliary aid to him at this hearing. That was his request. I allowed him to do that. He chose Mr. William Simmons, who, although Mr. Simmons was very honest and straightforward with the court, he is a licensed attorney. He reported to me that his South Carolina State Bar number, it's the South Carolina State Bar number, Mr. Simmons, right? Is 15882, and he believes that he was licensed in or around 1997, but in South Carolina. He's not licensed in North Carolina, and no one's represented is appearing as an attorney. He is here as Mr. Nelson's personal assistant. I'm grateful that he's here, and he is every personal assistant. I'm grateful that he's here, and he is every bit capable of describing whatever needs to be described to Mr. Nelson in this case. And to have a visual interpreter here, Mr. Nelson, would you not need that visual interpreter? That would be online, is that correct?
Judge, to your point on there's no certified visual interpreters, there are, the Americans with Disabilities Act does not require that interpretation be performed by someone with a certification, and as far as I know, neither does the state of North Carolina. Just because the state doesn't have a contract with certified interpreters does not negate the federal
I understand.
law.
They would appear online. That was your request, is that right?
The request I made was for a service that I am familiar with,
They would appear
that they
online.
have certified interpreters through an online system. Yes, Judge.
Thank you. I understand your, I'll call it objection to my ruling. The court again finds there are no certified interpreters. Mr. Nelson, the personal assistant that Mr. Nelson has brought to court, that would be Mr. William Simmons, excuse me, the personal assistant brought to court by the defendant is in a far better position, at least in no different position, to describe what's happening in as much detail as he wants to describe anything that's going on in the courtroom than someone online. The court finds that it would be it would fundamentally alter the way the court proceeds to allow the defendant who would have to provide someone he's identified as a visual interpreter through an online service. They'd have to be viewing the jurors. That means some type of recording device or electronic device might be a better description, would have to be shown to the jurors, especially given the history of this case with the animosity, whether it's for or against the defendant or for or against the state. Having electronic devices and jurors subjected to that would easily intimidate a juror or otherwise influence, an attempt to influence the juror's decision in the case. The court, I've been identified that Mr. Nelson, do you have an active website, social media platform in this? You're allowed to, I'm just asking if you do. There's nothing wrong.
What is the question?
Do you have a social media? Do you have a Facebook account, a YouTube account, or do you normally post anything online? Do you have many of your documents say Blind Justice. Is that a website that you have? Or?
Blind Justice was a news organization that I worked for. I do not own it or run it.
I asked it, I don't know, because some of your documents cite Blind Justice, or at least have that name on it. That's in the court file. All right, so do you have some type of social media platform
I do not own or run a social media platform with that name. No.
Okay. Do you post things on social media?
I contribute to news.
All right. And that's your right. And
I'm not the owner or operator of it.
Understood. Thank you, Mr. Nelson. And the court was given that information earlier based on what's throughout the file in this case, but I couldn't stop anyone from then publishing whatever video images of jurors that might be captured. It would be beyond my control. I would have no control over whether a video image of a juror is posted online or not, which would again go to the intimidation and influencing of a jury. So to control the courtroom, I have not allowed any type of visual or audio device for the defendant. With regard to the audio device, let me back up. The defendant also wanted an audio recording device for audio notes. I've denied that as well because the court reporter in this case, while she's also going to be able to provide a written trial transcript, she also has a voice recording going on as we speak. To avoid substantial interference with court proceedings, I'm going to have one person making an audio recording, and that's the official court reporter. And I'm providing the audio recording to the defendant. He was already provided one earlier today as to what took place this morning. There was really nothing significant at all. Nevertheless, that was provided to him, and another one will be provided to him at the end of the day. Today, if you will, Mr. Nelson, at the end of each day, just wait a couple of minutes. It won't take long to get it, but she can't get it from where she is right now. She has to retire to another room to make a copy, and she'll give it to you before you leave. I'll do everything I can to make sure that one is given to you either at the morning recess or at the latest the lunch recess. So you'll be given audio copies at least twice a day. Again, that's done to maintain court security, to make sure the court can control the proceedings, and otherwise is a reasonable accommodation. And I should note with regard to the visual interpreter, the denial, someone online attempting to provide visual interpretation, having Mr. Simmons here, if he so chooses, and Mr. Nelson so chooses, a far better option than having some visual interpreter that's not certified, and there's no guarantee that person will give actual visual correct visual interpretation. And without a certification process, there's no way to guarantee that person's reliable or unreliable, whoever it may be. The defendant's objected to that finding. The defendant also requested for the use of video recording devices for visual notes. My visual device prevents me from taking notes. I've denied that for the reasons I've already mentioned, the denial of the visual interpreter and the audio recording devices. I've also noted that he's been allowed his personal assistant that I described earlier, who can address any issues that he has about taking notes. Mr. Nelson's also asked that only one person speaks at a time. I certainly have allowed that, as I would require in all cases, but when I was making a ruling a minute ago, Mr. Nelson, you, I think, inadvertently, through no malice at all, talked over me when I was trying to talk. You probably thought I was finished, which is a reasonable assumption. But when I say only one person speaks at a time, I'll allow that. But understand, sometimes there'll be, for lack of a better description, incidental contact.
Yes, Judge.
And that's not the right analogy, but every now and then one or more of us is going to talk over each other. But the court reporter, we're very glad you asked for that, because it makes her life very difficult when two people are speaking at one time for obvious reasons. You've also asked the court that no threats, intimidation, or coercion take place. I've allowed that as I have required in all cases, and that brings me to the gentleman that was here that I asked to leave the courtroom. Quite frankly, when I asked him his name, he was very threatening to the court and attempted to intimidate the court by demanding various things, and he's not in a position to demand anything because we're in the courtroom where I've got to make sure both the state and the defendant are free from outside influences. I have no idea if he got that upset after asking a simple request as to what his name is, if he's going to try and hurt some juror walking in the courtroom or otherwise intimidate the juror. So for those reasons, I've taken the additional courtroom security precaution that I've already outlined and asked that gentleman to leave. I didn't take him into custody, he wasn't arrested, he wasn't charged with anything, but I eliminated the threat in the courtroom. The defendant has also asked for the use of a personal assistant. I've already allowed that, as I've indicated. The defendant asked that documents sent by email to be in OCR compatible format. I've allowed that. I don't intend to send any documents by email. The only other one I have is by the waiver that I've already stated in open court, so you can hear exactly what I did. That would be sent by email, but if there is a document to be sent or exhibit, the state's already identified everything. I don't think that will become necessary, but if there are types of voluminous documents that the state determines needs to be done, we'll do that, okay?
Yes, Judge. To clarify that request, if I worded it, the documents sent by email be sent via OCR, that was under the assumption that nobody would be handing the blind person physical documents, and so therefore all documents would be handed to me in a way that I could read within OCR format.
I understand. Well, sir, you have your personal assistant as an auxiliary aid at your request, and your personal assistant can help you. I don't anticipate, quite frankly, anything to be handed to you past what you've already received and had a chance to review well in advance of trial. Unless the state knows there are any other documents at this point or exhibits, I don't anticipate anything else to be handed to you, okay? Thank you, Mr. Nelson.
Your Honor, if I could.
Go ahead.
A piece of clarification on that. I know
Yes, sir, Mr. Cochran.
the typical process of introducing something into evidence typically is showing that to the defense before going to authenticate it. I still intend to do that. I was going to use Mr. Simmons to kind of help.
If you've already given him all the documents, it would have been helpful had you pre-numbered it. If you want to talk with Mr. Nelson and Mr. Simmons about the documents you've already given that will be pre-numbered, that will help. So when you say you're going to offer exhibit number 1, you've given them 2 Google Maps.
Yes, sir.
Which one's 1 and which one's number 2? If you could do that before you leave today, even if you ultimately don't offer one, I've asked the defendant to pre-number exhibits. They don't have to. But I asked that you pre-number exhibits. And if you know what they're going to be, go ahead and let Mr. Nelson know what they are so he can decide what, if anything, he wants to do about it when and if they're admitted. Okay?
Yes,
That would be helpful. Again, just because you number them in a certain order, you don't have to hit 1, 2, 3, 4, 5. It can be 1, 2, 3, and 8. And you just skip the other ones because you made a trial strategy decision not to offer. It will speed things along and give Mr. Nelson greater clarity as to exactly what you're offering if you'll do that before we finish today. Okay?
Yes, sir.
You've also, Mr. Nelson, asked all parties to identify themselves prior to speaking. We've done that in some form or fashion today. I think that's a good request. I would do that as in all cases. The court reporter would greatly appreciate that be done as well. But to the extent there's an incidental overlook, just alert it. If you're not certain, let me know, and we'll certainly correct that. And I'll take responsibility for that until it's my fault. I should have asked them to identify themselves for the record. It's not a problem. You've also asked for the use of your iPhone for access to court preparation materials and notes. You indicated that your phone is your primary assistive device that helps you take notes and access your court preparation materials. I allowed that request, but I'm not allowing you to record anything by video or audio here in the court. Okay?
Right, so my ability to take notes I don't have that ability, Judge. I take notes with audio, and I have other forms of audio devices that I could use and would bring into the courtroom if you would allow it.
I'm not allowing anything to record what's said in here. If you have to speak into your phone and it records what you're saying, I'm proud of that. If that's what you're saying. I'm not going to allow anything, though, to record, to duplicate what the court reporter is doing.
Okay, so may I bring in I have a separate VA issue, it's a 312 milestone recorder that I can use to make my own audio notes to then refer back to for, if I'm doing a cross-examination, I need to take a note during direct examination. I can't do that without that ability, Judge.
Describe to me better what it is, because I don't understand.
It's just an audio recorder. It doesn't have any, it's tactile. It's made for people with visual impairment. So it's just, I can press a button and give myself a note to remind myself to ask a question based off of whatever the prosecutor's doing.
Okay, how big is it?
It's 2 inches.
So it's your cell phone or smaller?
Yes, it's smaller than my cell phone.
All right, Mr. Nelson, can I have your word you're not going to be recording anything? When you say recording device, it tells me you're trying to record what people are saying in the courtroom. I don't want you using it for that purpose. You're using it for your own note-taking. I'm okay with that.
Yes, it'll be used for my note-taking. It won't actively be recording.
You will not actively be recording anything or trying to duplicate what the court reporter is doing. Is that
correct?
Do you still want the addition of the court reporter at the end of each day?
Yes, because that's, if I can't record the entire thing for my notes, then that would.
That's fine. And I'm going to, based on your better description of what your I'll call it a personal recorder. I know that's not the right term, but from my point of view, you may bring a personal recorder tomorrow to take your personal notes the way you described it.
Okay.
But again, I want to be clear, you're not to video or audio record anything in general going on in the courtroom. The video recorder is for your personal use only, to record your personal description or reminders of what you want to do. Is that correct?
Yes, Judge.
All right, Mr. Nelson, I'm not threatening you at all, but I have to be clear. If you violate any of my orders, if I find that you're audio recording, I'm not saying you will, but I have to say this before I can do anything. If you audio record anybody like the court reporters do it, or you video record anybody, you could be held in contempt of court. I'm not saying you will be held in contempt of court. I'm saying you could be. You understand?
Yes, Judge.
Okay. And if you're held in contempt of court, I'm not saying you would be. But potential punishments for being held in contempt of court include going to jail for up to 30 days. It could be 1 day to 30 days, or fine anywhere from $1 to $500. Do you understand?
Yes.
All right. You've also asked to bring in your Bluetooth headset to help you with the iPhone that I allowed you to bring in, and presumably it would help you with your personal recording device. Would that be correct?
Yes, Judge, I'm currently wearing it, and to that point, I can help you understand what this does as well. It's a bone conduction headset, so it.
You're not talking on the phone when you're recording.
No, it blocks. I'm sorry, it doesn't block my eardrums. It goes through the bone, the mandible. That way, I can hear the court. But if I'm using my notes, trying to refer to something, then I get audio from that and whatever is happening in the court. So I respectfully request the court if you could try to pay attention when I am touching my phone. I'm listening to my notes, just like you can see when an attorney's shuffling through his papers that he's trying to find his train of thought. And
Okay.
I'll try to give you that same courtesy to minimize the talk in the court, because I can't hear what's happening in the court and review my note at the same time.
Mr. Nelson, I'll do the best I can. You have your personal assistant. If he needs to alert the court to wait just a minute or to take just a moment, he can help assist you just like you asked him to. That's fine. I want to be clear too, Mr. Nelson, you're not to communicate with any person outside the courtroom with your devices. My understanding is you're using your phone, the Bluetooth, and what I call the personal recording device for your use here in the courtroom, in this courtroom only. Is that correct?
Yes, Judge.
Okay. I just want to be clear. I don't know until I ask. I want to be clear you're not talking to somebody outside the courtroom or anyway publishing anything on the website or whatever news organization. It's fine to be part of the news organization, but it's not fine to be communicating with them while you're in trial. You understand?
Yes, Judge. I'm not willfully or knowingly doing that.
Okay.
I don't know what Google's doing behind the scenes with my phone.
Well, if Google, if it comes to my attention that if you can't control your phone and there's third-party communications, you could be held in contempt of court. You understand? You're in control of your phone. You shut down Google if you need to shut down Google. But what you're telling me is, well, what I'm telling you is you're responsible for your phone. I've allowed you to use it under the circumstances I've described. If I find out that you're communicating, your phone's communicating with anybody else, you could be held in contempt of court. And I'm hereby putting you on notice, you are in control of your phone. If you can't control Google, then don't disconnect from Google during the course of this trial. You understand?
I use a Google Drive where all my notes are in the cloud, so I rely on it to have access to my notes, Judge.
Well, I'm telling you, if you wind up, if it turns out to me, and there are quite a few detectives in here, if they wind up finding out that there's something being published about the trial, you are going to be held responsible for anything emanating from your phone. And to simply say, you can't control that, that's not acceptable to the court. So I'm going to leave that up to you tonight to figure out how best to manage that, okay? I'm working with you, but you need to work with me as well.
I was mainly just referencing the state of smartphones, lack of security, Judge. That's just the world we live in today.
Well, understand the world you're in here in the courtroom. If I find out there's third-party communication, I'm not saying you will, I'm saying you could be held in contempt of court. You understand?
Yes.
Okay. You've also asked for the SUNU. I probably mispronounced that. That's S-U-N-U band electronic obstacle detector. I understand that's allowed. You've asked for your white cane. I understand that's allowed. You asked to wear your ball cap. I initially denied that request, but upon further review of your reasons for wearing it, I allowed you to do that along with the dark sunglasses. I initially denied that request, but upon further review of your purported medical offenses, I've allowed you to wear that. You've also asked for batteries and cables to charge your prosthetic assistive devices. And you define those assistive devices as your iPhone, the Bluetooth headsets, and the obstacle detector. So you're allowed to do that, okay? That's what the court's done. I understand your objections to the ones I didn't allow, but I'm not changing my rulings based on for all the reasons I've already mentioned. All right, that brings us, the best I can tell, to the pretrial motions. We're here at almost a little bit before 5. What pretrial motions do you need heard, Mr. Nelson?
Judge, I respectfully request the court that we address the motion to dismiss as it pertains specifically to what we just reviewed.
Okay, go ahead. I see that you filed a written motion to dismiss on January 24th, 2022. Do you want to rely on the motion, or do you want to be heard in more detail?
I would like to be heard in more detail, Judge.
Go ahead.
This motion to dismiss is pursuant to NC General Statute 15A- I think it's 974, excuse me, 954, subparagraph A, subparagraph 4, which states that it's proper if the defendant's ability to prepare a defense is hampered because of constitutional violations. And it's also pursuant to the 5th and the 14th Amendment. The issues before the court is due process. And the case law is Tennessee v. Lane. And the case law is Tennessee v. Lane. And I can send this in again, Judge, via email, or if you need a copy, we can hand a copy up, I think. But to the point of handing up a copy, I've tried to argue this earlier, and the judge, I think you keep insisting that I use my auxiliary aid as an interpreter. Let me direct your attention to federal law. It's 28 CFR 35, 160, and that's subpart C. And again, I can email this into the court so you can have a copy of it, Judge. But that's the federal codification, or one of the federal codifications for the Americans with Disabilities Act. It specifically says that a public entity cannot force an individual to bring another individual to use as their interpreter. And that's what's happening in this case. This morning, Your Honor, you ordered my auxiliary aid to read the document to me, to act as my interpreter. You've done that with the maps and with the videos, and that's directly in violation, as far as I understand, with the American Disabilities Act says. Again, that's 28 CFR 35.160, subpart C, talking about communications. The other aspect there, or federal statute, is 42 USC 12201. Talks about accommodations. You go to subpart D and it says that a person with a disability cannot be forced to accept whatever accommodations are being offered by a public entity. And it also says in that section, I believe, not in subpart D, but in 42 USC 12201, that primary consideration for accommodations is to be given to the person with a disability. As I not only have visual impairment, but other disabilities, my auxiliary is helping me with primarily the other disabilities I have, and not so much the visual impairment. The visual impairment issue, I've asked for an accommodation via a visual interpreter to get access to real-time visual information in the court, whether it be body language, facial expressions, who's speaking. That information is vital for understanding the veracity of a witness, of whether or not they appear to be telling the truth. The same thing with voir dire of the jury. And it's also, I would say, it's essential information for anybody on either the defense or prosecution side to be able to see the judge and get kind of body language cues or facial expression cues from the judge to know when to kind of slow down or back off the line of questioning. I don't have the privilege of that, Judge, and visual information, real-time visual information is essential information. There's bountiful case law across the country. I think one here in North Carolina is State v. Smith that specifically talks about at the appellate level, the appellate court just has to rely on a cold transcript. And that's why they give Your Honor more weight, because you get to see, you have the privilege of seeing what's happening in the courtroom. That emphasis is echoed in every state across the country, in every appellate court. Being able to see what's happening in court is vital information. I would say it's a substantial right. And to be denied that information is a violation of the 5th and 14th Amendments and the Americans with Disabilities Act. Tennessee v. Lane, the Supreme Court actually upheld or ruled, that was the first ruling on it actually, they ruled on that, saying that it's a 14th Amendment issue, it's a due process issue, and they found that people with disabilities have been struggling to get access to public services and public entities across the country. They did note that the country is slowly moving along with getting access to persons with disabilities, but many states had eugenics programs where they sterilized persons with certain disabilities just a few decades ago. So where we currently stand, and this was maybe 17 years ago with the Tennessee Lane case, we haven't gained much in regards to getting equal access in public entities and in the court. This case is we're coming up on 2 years, and it's been a fight just to get into court to be heard. It's been a fight to get the attorney that I had to advocate for equal rights when he didn't have a fundamental understanding of the ADA, which I told you earlier was the reason I fired him, one of the reasons I fired him. And let me refer to my notes, please, Judge.
Okay. Record reflect that the defendant is reviewing his notes now on his phone. He's given free access to the notes that he's been using. And he's been using his notes on his phone throughout this colloquy or his statement to me regarding this motion.
Okay, the other section, Judge, draw your attention to is 28 CFR 130, and it's going to be subpart 7I. And that says that the public entity is required to make modifications to policies to make sure there's effective communication and proper accommodation to a person with disability. As it currently stands, the court is making no accommodations to me to have access to digital information in the court, except for trying to force my auxiliary aide to be my interpreter, which again violates the statute I just referenced, Judge.
Okay, are you finished? I just want to make sure I'm not talking over you.
Yeah, let me double check.
Okay, the record reflect he's reviewing his notes again on his phone. This federal code on coercion, threats, and intimidation is 42 U.S.C. 12203. It also, in there, explains that it doesn't just pertain to the person with a disability, but any person that is accompanying that person and is assisting them to be able to enjoy equal access. So that, in this case, that extends to my auxiliary aide, Mr. Simmons, and the order this morning that Judge, when you ordered him to read and be my interpreter, I would say also
falls in line with that federal code, Judge.
All right, Mr. Simmons, did you feel intimidated or threatened when I asked you to do that?
Well, it was an order, but
Did you feel intimidated or threatened?
I rarely feel intimidated.
Say that one more time.
I rarely feel intimidated, but no,
Okay.
I have to be honest, I didn't feel intimidated.
Oh, thank you, Mr. Simmons. I appreciate your honesty. And you said you weren't intimidated, is that
I
right?
was not.
All right, Mr. Simmons, I appreciate your honesty. Court, Mr. Nelson, thank you. I reviewed your motion. I've had a chance to listen to you, and I appreciate the fact that you've been able to review your notes in detail. I didn't. I see it why you need the phone with you to review all your notes like you've been doing. In any event, your motion, I note that your stated reasons regarding your assistant with regard to threat and coercion are denied on its face and without merit, based on what your assistant just told me. He's not been intimidated. I find that as a fact, or threatened or coerced. I find Mr. Simmons has been at all times respectful. He looks professional. He has been nothing but professional, capable, on time, and the best I can tell, a good friend of yours for being here with you through all this, even though he is an attorney, but simply not in North Carolina. With regard to your concern and objection to the court, with regard to reasonable accommodations, the court is, your motion is denied. It is meritless. I understand your argument, but the court just went through all the accommodations and changes that I've made at your request. I denied some initially, as I put on the record, but when you asked for further, or when you gave me further explanation, I changed my ruling, just like I did with the lights in here. You had your blindfold on this morning. You told me about the lights. I further considered the lights have been dimmed. You told me earlier that the lights are satisfactory at this point. I listened to you, and I changed and made reasonable accommodations or outright granted your request. Granting the visual and audio devices that I have not allowed you to bring in would alter the fundamental proceedings of the court and the process of the court for all the reasons I've already mentioned. I won't repeat everything. Also, again, the fact that there's no certification process for a visual interpreter simply opens up the court and the system to you claiming the visual interpreter didn't do a good job. There is no guarantee that someone online looking through at the jurors through some electronic device is going to be able to give you any accurate sense of body language or anything else. And that's the person or the entity that you brought to my attention. Mr. Simmons is here, not at my request. I didn't order Mr. Simmons to come to court. You asked in your request to bring a personal assistant as an auxiliary aid in the hearing. I allowed that request. He has not been intimidated based on his own statement, and I am asking him as your personal aid and auxiliary assistant to simply provide, Mr. Simmons, this is not an order. This is a humble request. As an attorney in another state, I know that you aspire to the highest professional obligations of the state of South Carolina, which is a fine state. And I know if you practice in the federal courts are even more formal in my experience. You may tell me otherwise, but in my experience, federal courts are even more formal than state courts, and I know that you aspire to the highest standards of your profession. And even, I don't know your relationship with Mr. Nelson, and I don't need to know it. I can tell that you're at a minimum, at least a friend, and I know that if, to the extent it's pro bono work, even though you're not here as an attorney, you were very honest with the court and didn't try to represent yourself to be an attorney in North Carolina at all. You can comply with my humble request, and our only request, to describe whatever Mr. Nelson needs to be described. You are here in the courtroom. You have training as an attorney that would be better than someone on online service. You, as an attorney, most attorneys have quite a bit of attention to detail. If you're here with Mr. Nelson on this case, there is no doubt in my mind that detail is very important to you. Otherwise, you wouldn't be here. All right, so your motion is denied. All right, I'll note your exception to my rule, Mr. Nelson.
Can I be heard anymore on this matter, Judge?
Okay, if you don't repeat yourself, yes.
Okay.
I'm not trying to be difficult, but if you've already said it, the record's not erased.
Right. The North Carolina legislature have codified a whole chapter in the North Carolina General Statutes. It's North Carolina General Statute 8B.
8 as in B and boy?
B as in boy.
All right.
Yes, Judge.
Yes, sir.
And that chapter specifically says that public entities are required to provide interpretation for the hearing impaired. There is no codification for the visually impaired. And the reason I argue is because it's not in the numbers. The numbers of people who have visual impairments in the country is far less than those with hearing impairments. The technology advancements for the hearing impaired is decades ahead of where the visually impaired technology is. But we're catching up. Like body-worn cameras with real-time description is where we're at right now, and that's almost in action. And so for your benefit, Judge, that's where the technology stands. For the state specifically doesn't require it in name that the visually impaired have a right to visual information in court or in public settings, but they do have a codification similar to the ADA. It's NCGS 168A, and it mirrors the language of the Americans with Disabilities Act, which I gave you previously, requiring the entities to make proper accommodations. And at this point, Judge, I'm not hearing the court offering any accommodations to give me equal access to visual information. And the other option I offered in our communication before this hearing was for the other party, prosecution, to also be limited in visual information and to have them wear a blindfold. And that's not as a joke or to make a mockery of the court. That's just to explain the levity of the situation that I think.
I'm not going to have everybody blindfolded, Mr. Nelson, but I'll be glad to have the jurors wear masks. Would you like me to do that above their nose?
I didn't get the last part.
Well, I'm taking my mask down. I'll be glad to have the jurors wear masks at all times above their nose. Would you like me to do that? That way no one will see their facial expressions. But that would include Mr. Simmons. He won't be able to tell you what their facial expressions are because their masks will be covered up. They're covering up their faces. And in the pandemic, everybody's going to be wearing a mask anyway, except when I'm talking to you like this so you can hear me clearly. But I'm glad to do that. Will the state object to that if I did that?
No, Your Honor, that's fine.
All right, the state's wearing a mask right now, covering up his nose. You're not wearing a mask. And I should have noted you asked not to wear a mask because you have some type of medical condition. I would note Mr. Simmons has worn a mask the entire time he's been in court. You're the only one, looking in the courtroom, the only person not wearing a mask is you. That's at your request. So to say you haven't made, that I haven't made accommodations is simply wrong on its face. But you've asked for everyone to wear blindfolds. I'm not doing that. But would you like me to have the jurors wear masks? That's my request, my question to you. Do you want to think about it? You want to think about it overnight?
Yeah, I'm not understanding what kind of mask, like how much of the face would it obscure?
It would cover up their nose, just like the pandemic mask that everybody's wearing in the courtroom. I'll have every juror wear it, try to cover up their nose. So that way, no one's going to be able to see facial expressions. Not you nor the state.
Body language, that doesn't help with the issue of body language and if a juror's shifting and shaking their head or rolling their eyes, like.
You've got Mr. Simmons here that can alert you when that happens. I have made plenty of accommodations. I have given you visual, everything I can do, I have done. The reasons why I'm not going to do the things I've already said. Okay, I understand you object to them, but that's where we're going. If you want to reconsider, I'll let you consider the face mask. If you would like to do that over the night recess, I'll be glad to do that. I can't, without being able to see their face, I don't know how. Body language is not going to be an issue. Rolling their eyes could be. Mr. Simmons, is there anything that would prevent you if somebody rolls their eyes to simply let Mr. Nelson know that juror A, B, or C is rolling their eyes? That rarely happens, but if it does, would you be willing to do that?
I would be willing to tell you that.
Okay? I don't know, in any other issue you and Mr. Nelson work out, you don't need to bring to my attention, Mr. Simmons. However, it doesn't offend me. If you're talking, I give you free range during the course of this trial. And if you will simply alert me, again, I can't read your mind, but if you need a minute to talk with Mr. Nelson, or if you need me to slow down because he's reviewing something or making a note, as he told me earlier, if he's working on his phone, if you can just let me know. You can either raise your hand or say, Judge, could you give us a moment? I'll do that. Can you do that, Mr. Simmons?
Yes.
Okay, and you've got free range to interrupt me if I'm in the middle of something because I'm paying attention to something else and not what I need to over your desk. Just let me know. I'll stop what I'm doing and we'll address the issue, okay?
Yes, sir.
All right. Okay, Mr. Nelson, anything else on that point? Otherwise, other than I know you object to my ruling, I've heard you, and consider the mask for all the jurors, okay? And you won't tell me now, tell me in the morning. Does that work for you on the mask issue?
It's your discretion, Judge.
No. I'm asking you. I'm not going to blindfold everybody. That would lead to potential accidents in the courtroom, especially if jurors don't know how to walk with the cane. It takes some learning to be able to do that. That's a security issue. But I will absolutely cover up their faces with a mask. We're here at the pandemic. I'm leaving that up to you. If you want me to do that, I'm telling you I can basically cover up all their facial expressions. But to do that, Mr. Simmons, unless he has an extra gift that I'm aware of, will not be able to see through anyone's mask. He will not be able to tell you any facial expressions because they'll be covered up. I'm leaving it up to you. If you want me to do it, I will gladly do it. If you don't want me to do it, I'll make them lower their face mask. They'll be wearing face masks unless y'all are asking them, you and the DA are asking them questions. If you want me to have asking them, you and the DA are asking them questions. If you want me to have them lower their face mask so Mr. Simmons can tell you what their facial expressions are, I'll gladly do that. If your position is you don't want that done, I'll leave their face masks on so that neither you nor the DA can know what their facial expressions are, okay? Mr. Nelson?
Yeah, I still don't,
I want you to think about it overnight, and we'll revisit that issue in the morning, okay? Talk about it with Mr. Simmons outside of my presence, or whoever else you want to, that's fine. You indicate you might consult with someone, not an attorney, but you might consult with someone, doesn't matter to me, that's up to you. All right, Mr. Nelson, what other pretrial motions do we have? Do you have?
I think we have a simple motion to sequester witnesses, Judge.
You have to say that one more time?
A motion to sequester the witnesses.
All right, what's the state's position on the sequestration of witnesses? Can you do that?
Yeah, the state has no objection to that. We just asked for a reciprocal order for the defense.
Okay, that will be allowed. It applies to both sides. Mr. Nelson, you do not have to tell me, you don't have to make a decision, but do you know if you're going to call witnesses at this time, or are you not in a position to make that determination yet?
Currently, I don't have any witnesses in addition to what the prosecution's witness list is, Judge.
Okay, you're not being held to that. So if you change your mind based on trial strategy considerations, I'm not holding you to that. But what I'll do then is I'll allow the defendant's motion for sequestration. You'll be allowed to designate a case agent to be here during the entire time, and if the case agent happens to be the same person that's going to be your first witness, if it's not your case agent, can be here because that's going to be the first witness. They won't hear any other testimony, but otherwise have the other witnesses right outside the courtroom. Since you only have 3 witnesses, is that right?
I should have, I believe, 4 witnesses.
Okay, who are the witnesses again?
Y'all may approach. I have the witness list that I've already
No,
provided.
you need to give it to me. You can give it to the clerk after we're done, but if you could just identify the witnesses, please.
Will be Officer Benfield, Officer Doss, Officer Michael, and Kyle Ray.
Were all 4 of those witnesses testify in the district court hearing?
The only one that did not testify in the district court was Officer Michael.
And what's Officer Michael? What's the purpose of calling him? I'm just asking.
He was there on the scene. He was just not called in district court.
Okay. All right. And the court should know that with respect, other than Officer Michael, the defendant, going back to his complaint about no visual interpreter, again, I'm not changing it. I've already said, but the court's given the defendant the opportunity to review all the videos. Again, this is the 3rd time the defendant's reviewed the videos. This time it was with Mr. Simmons. The previous 2 times that I've already identified for the record, was with Mr. Holt. The defendants also had the opportunity of hearing 3 of the 4 witnesses already testified in district court. All of that won't be coming in because this is a de novo hearing, but nevertheless, court just notes that for the record. All right, other pretrial motions.
Yes, Judge, I have a motion to suppress.
All right, I read the motion to suppress. You're going to need to call evidence for that. Why don't we start with that tomorrow?
That's fine.
Okay? Let's do this. Sheriff, if you could please let Ms. Red know, the motion to suppress, quite frankly, I think is significant. I assume you're going to have case law on this point on behalf of the state?
Yes, sir, and I've already provided that to Mr. Nelson.
Pardon me?
I've already provided that to Mr. Nelson.
All right, Mr. Nelson, do you have case law? I reviewed your motion. I think it's a significant motion. Past what's in your motion, are there other cases you want me to consider, or is it all in your motion?
I have other case law that I will offer the court. I can email. I have it drafted. I was ready to present it via my email, like I said earlier. Judge, I can send that to you just in a minute.
Okay, if you just have the sites, I'll pull them up. Unless, are there 20 cases, or do you have 2 or 3, or how many?
I think maybe half a dozen.
All right, how about if you could print them out and just bring them to me tomorrow? I won't look at them tonight. I'm going to wait, because what I'm going to do, Sheriff, let us read that, bring jury in Wednesday morning. Can you let us read that Wednesday morning for the jury? I'm sorry. You tell the jury Wednesday morning. How you doing? Good to see you. If you don't want to do that, I appreciate that. All right, the motions to suppress, I just go slow. How many witnesses do you anticipate calling for the motion to suppress? I'm not holding you to this.
I believe at this point it'd be 2 witnesses.
All right, you'll have them ready to go tomorrow morning at 9:30. Unless I'm wrong, I don't know, Sheriff, we don't have any other civil matters to your knowledge, do you? No, sir. The civil matters take 20 minutes, as you can see, lasted an hour and a half. So I don't think there are going to be any other civil matters tomorrow. You'll be the only show in town. We'll start with the motion to suppress after about 9:30, okay?
Yes, sir.
Anything else from the state that you want me to consider? Or anything else we can say today before we take a recess?
Nothing I can think of, Your Honor.
Mr. Nelson, is that your last pretrial motion or do you have others?
I believe so. Is the motion to continue withdrawn?
Oh, yes, the motion to continue, I've read it. I'm denying the motion to continue, but in effect, we're not getting everything. And it in effect grants it by default because we haven't gotten to the trial, but we want to get to the trial tomorrow, but I'm still denying the motion to continue. Your motion for scheduling, by default, we're not starting until Wednesday, so it's altered some, but I didn't grant your motion, but we're just not going to be able to get to the trial until earliest Wednesday morning at 9:30, okay?
Yes, sir.
All right, Mr. Nelson, anything else that we haven't discussed at the moment? It doesn't need to be, I just want to make sure there's not anything I've overlooked.
Let me check with my auxiliary aide and see if I have any of my notes.
Check with your auxiliary aide.
Okay. Mr. Simmons is requesting the ability to bring in his cell phone, as he's a bar member from the South Carolina Bar.
And when I come in, they make me take my bell off and stuff.
When do you need your cell phone? Well, I'll let Mr. Simmons have, you Mr. Simmons, I'll let Mr. Nelson have his cell phone, but do you need your cell phone to work with Mr. Nelson?
Well, some of the files are on my OneDrive, the video files, and some of the motions. I have to have access to it. That's how
So here's where I am, Mr. Simmons. You've been nothing but good to work with up to this point in time. Can I have you represent to me as an officer of the court, even though you're not a North Carolina attorney, that there'll be absolutely no communications with any parties outside of this court?
Absolutely.
You can represent to me that?
Yes, Your Honor.
All right, same contempt provisions apply to you if I find out that you're communicating. I'm not saying you will. You've been very straightforward with me. If I find out there's any communication with any third parties, you could be able to contempt. You understand?
Yes, Your Honor.
I'm not threatening you. I just want to make sure everybody understands how serious
That's fair.
their representation to me is. All right. So what I'm going to do is let you bring your cell phone in. Sheriff, you understand? Mr. Simmons can bring his cell phone in. You with me? Yes. The purpose is for you to assist Mr. Nelson. And you've been doing that just fine. If that will help your assistance to be more efficient with Mr. Nelson, that's fine, okay?
Yes.
All right, thank you all very much. Y'all have a good day. Sheriff, from recess tomorrow morning, 9:30, please.
Recess 9:30 a.m.
All right, thank you, Sheriff.
Mr. Cochran, do we have video or anything we need to
Stay tuned for more. Thanks for watching. Deo presso, liber.